So there are certain things in interview you absolutely cannot ask about. You cannot ask somebody about their medical information because that gets you into whether or not they have disabilities. And you cannot ask them about genetic information, their family's medical history either. That is off limits completely. Even if you notice they have a disability while you're interviewing them, right? The guy may have a disformed hand or some other thing that's going on. You can't specifically ask, hey, what happened to your hand? But I could say, hey, this job requires you to do a lot of typing. How do you think you're going to be able to do that? That's actually asking questions about the job and not about your disability.
Hey, this is Chaz Roberts. I'm a personal injury lawyer. It's my passion to bring the law to the people, and that's the purpose of this podcast. You are listening to Law Have Mercy. On today's podcast, we have our returning guest, Scott Guidry with the Guidry Group. What's up, Scott?
Oh, glad to be back, man.
So last time we talked about firing so much, and so many people had great feedback. Love the episode. I thought we would bring you back to talk about hiring.
Oh, yeah, man. That's a whole world of problems that an employee or a business can get into is right at the beginning of the relationship with their employee as opposed to the end, like we were talking about last time.
Is it that big of a deal?
Man, that deal can be something that can really hurt you because now you can be caught and be in a place where your company could be liable and have to put out a lot of money for somebody who never actually did anything to be productive for your company.
So it could cost you money before they even start.
Right. And they may never start. It may be because you didn't hire them.
Do hiring laws apply to all businesses, or do you have to be a certain size business?
No, hiring laws will apply to any business. We have the federal laws especially apply across all states. It's a lot of cases. Some of the stuff we'll talk about, it's not even, are you in Louisiana? Are you in California? Because some states are really protective of their labor force, whereas some aren't.
Where does Louisiana stand?
Louisiana is probably one of the least protective of its workforce, but I mean, that doesn't mean that those federal laws don't really do a lot to protect us. We have a lot of things, and sometimes it comes down to what administrations we have in place too, because so much of our labor laws are done more through regulation than they are through actual legislation.
Where do you think that the job interview process or hiring someone, where does that start?
Man, I mean, you can get in trouble with just your job postings. Right. You haven't even chosen a person to interview yet. You haven't read a single application yet. But if your job posting already is putting you in a place where you are at least in the light of the posting being discriminatory, because you cannot be discriminatory. And I'll say this now, race, color, national origin, sex, which includes your gender identity, your sexual orientation, and whether or not you're pregnant, your age, and genetic information and medical information. We talked about disabilities before. All of those things put you in what we call protected classes. So, we'll use that term going forward. But if you, in your job postings, are saying, I'm not going to want to hire somebody in any of those protected classes, right? I'm looking for young, energetic workers. Well, now I'm now saying that, hey, if you're old, don't bother applying. And that it can be seen as discriminatory. And now you could end up with some issues coming from the federal government or from the people actually applying themselves.
Let's take a step back. Job posting, is that literally a post, a sign on a post? What is exactly a job posting?
So a job posting, yeah, it could be the sign up on the bulletin board right at the job fair. It could be the actual job fair itself if you show up there. It could be somebody putting it on Facebook. I see that all the time. Hey, my local business over here is hiring and looking for this kind of person.
Does that also include Indeed ads?
Indeed, Monster, LinkedIn, all of those places are all job postings. And a lot of times when somebody makes a job posting, they end up reusing it all across all those platforms.
So you telling me that I own a small bakery, and I'm trying to hire someone to work the cash register. I have to be mindful of what I put on the posting?
Yes, you do. I mean, if nothing else, we talked about before, and we always will, right? What did you put as something that shows evidence that you may have been discriminatory? Because you may end up hiring somebody mostly because they fit the model of your business, right? I think they're going to be good with my money at that cash register. They're going to be very good with customer service. And I chose that person. But now that posting is out there and somebody else may say, you didn't hire me because I was black or because I was female or because I was 50 years old.
Who has the right to bring that type of claim against a business?
The person who was discriminated against or felt like they were. And that's where the posting can get you in trouble is now you didn't even choose them for an application or a interview.
And that person has standing to file a suit?
Well, you've now put it out there. Don't even bother applying.
That's crazy. So what are some examples? I mean, you mentioned the young, energetic. I've seen that a lot on post. What are some other?
A lot of them come down to sometimes around the sex, the gender of someone, because we tend to think, or some businesses tend to think that that role is typically of that gender. And that is no longer the case. And a lot of things is people, we put them in certain positions because of their abilities, not because of these certain attributes they have that they have no control over.
Well, how does a company, let's just say like Hooters, right? How does Hooters get around hiring only female waitresses?
Well, they actually got sued by a male who wanted to go work there. And mostly, I think he was just trying to prove a point, probably get a little settlement money too. And he won. But the thing is Hooters said, sure, come work, put on those shorts and that T-shirt and go walk around. And the guy didn't really want to do that.
So what are, I mean, is this, can you potentially discriminate against a certain protected class and it still be legal because the job requires a certain attribute?
Yeah, I mean, you have some stuff we call disparate impact or disparate treatment. Those are two standards they look at, but that comes down to like, I might have a test that says, hey, you got to be able to pick up 150 pounds to do this job. That might be what my test says.
And that might disqualify a lot of women, just
correct.
For example.
Yes, women tend to be less strong than men, not always, right? There are men that maybe not be able to pick that up, but now we're talking about there's a disparate impact. More women than men are going to not pass that test. So now we've treated them differently, even though I didn't come out and say I'm not hiring females. But if you can prove that that test or whatever that is that you're using to discriminate, even though it's not on its face discrimination, is really required to do the job, then you actually have an exception to that. So let's say at the fire department, they want you to be able to pick up 150 pounds and throw it over your shoulder. Well, there's a reason for that because you have to go rescue somebody from a building and bring them out. So I don't want a fireman that can't go in a building and actually rescue people. So that's a bona fide job qualification is what they call it. But if I wanted Chaz at your law office, hey, you need to be able to pick up 150 pounds, that's not really something that's a bona fide job qualification.
I'm using it as an excuse to only hire a man or a certain type of physical
right
attribute, but it has nothing to do with the job.
That's where you get in trouble.
How does a person protect themselves in a job posting? What would be your advice on if I'm a small business and I want to post a job, what is your advice?
I would tell you to post only the things that are truly required to do the job and do it well for you. That's going to do a couple of things for you too, though, right? It's also going to get you the best applicants because you're going to say, all I'm worried about are these things that require the job to be done well.
And what would you stay away from posting?
I wouldn't talk about race, color, religion, all of those things we talked about as the protected classes. Just don't mention them because they're not necessary. And we know these days, most of that stuff or all of that stuff doesn't really correlate to how well you can do a job.
Is there any issues with offering certain type of pay on interviews?
Yeah, you can get into trouble. I mean, if you want to tell somebody, hey, this is going to be a salaried position, and that might not be something that by law, we have certain places where you don't get to, as the employer or the employee, decide if you're going to be an hourly or a salaried employee. The law says in certain circumstances that person's always going to be hourly no matter what. And you also have cases where employers sometimes it's not, we talk about employers, but sometimes people work for a company as an independent contractor versus what we call a W-2 employee, one that actually gets a paycheck every week. So those kinds of things can factor in as well.
You mentioned that certain positions have to be hourly. There's a white collar type exception to hourly, right?
Yeah, so the general rule, the Fair Labor and Standards Act came out a long time ago, back in the Industrial Revolution days. But they basically said everybody has to be paid by the hour, and once they've worked over 40 hours in a week, they get overtime. So we all know about overtime. But what the law provided, and over the years we've built more exceptions, is certain people are exempt from having to be paid overtime. The main three exceptions are the executive exemption, the professional exemption, and the administrative exemption. So with an executive exemption, if I want to say, hey, I'm going to pay you a salary, I basically have to show that you're somebody that's going to be acting in an executive role in my company. What does that mean? You're actually the one managing people. So usually we want to see that you're managing 2 or more full-time employees, and you have the ability to hire or fire those people, right? You can't just be the team lead that's out there. We really want you to be able to be one that's actually truly managing that company or some part of it. A professional exemption comes down to people like me and you, right? You actually have to have somebody who has taken a learned course and become a professional. It can't just be somebody who got a certification, maybe passed a test. They actually have to go through some specialized course of training, usually some kind of college degree or professional degree. And then the last one's the administrative exemption, and that is your clerical personnel. Most of the time, the example is a secretary, somebody that helps out with the managing side of the business, but isn't doing clerical or data entry work that's actually the work of the business. So for somebody like you, maybe your secretary would be an administrative exemption. Your paralegal, if she went to paralegal school, could be somebody that's considered a professional exemption.
So I bet there's been hundreds of fast food restaurants that have tried to designate people working the register, working the fryer as a manager, shift manager, or something to that effect to get around paying them overtime.
Oh, yeah. And so
I'm not familiar with any of the suits, but I'm sure there's been a lot of them. Right?
There is. And so the other part of that exemption test, I gave you the job duties part of the test. Every one of those exemptions requires a salary test. Right now, that comes out to about $680 something a week. It's about to change probably in May.
So you have to pay them a certain amount of money too to also be considered
to be able to get into that exempt status. So yeah, somebody like a McDonald's may not be paying their manager quite enough money. This is something that's actually been pretty contentious. Is what is that salary test going to be? During the Obama administration, they actually raised it to almost over $50,000 a year. That caught a lot of people that now said these were people, paralegals in some cases I saw with law firms. They were paying their paralegals a little bit less than that. And now they're like, well, I either need to raise their pay or start paying them by the hour and worry about overtime.
So I think if you're listening to this podcast and you are not being paid a salary, or if you're being paid, you are being paid a salary, but you don't fit within these areas, right? You're some type of professional. You have actual managerial type duties of hiring and firing and supervising and calling the shots, or a secretary to someone that's doing that, and you're still getting a salary, you could have a claim for unpaid overtime wages.
Correct.
I mean, is that fair?
Yeah, and look, when we talk about...
Because the payment test of how much you make is in addition to the job testing, right?
Correct.
You can't just pay someone a lot of money. You have to pay them money, and they have to fall within that classification.
And that classification, those ones I talked about earlier, it has to be their primary job duty. So let's say I have the manager on staff that's also the one taking people's orders. If their primary job duty isn't doing those executive functions, managing, hiring, firing, all of those things, if, let's say 70% of their time at their job, they're just taking orders and doing things in the register, they may not have met even that first test of did their primary job duties meet the exception.
And what would those people do? You file a lawsuit against the business?
You'd come to the business. You can actually go and go to your local Department of Labor too if you want and lodge a complaint there.
From what I know, once you make a suit, or once you file suit or make a claim for unpaid wages, aren't you protected against immediate firing?
So that's something we have in so many areas of employment law, is that there are protections against retaliation.
Against retaliation. I'm sorry, I couldn't think of the word.
Yeah.
There
So,
you go.
If I file a workers' comp claim and I get hurt, you can't fire me because I have too many workers' comp claims. You can't fire me because I made a complaint about sexual harassment. And it goes to the same thing as if I say, hey, I don't think you're paying me right, and you decide to fire me over that, we're going to have problems.
Do you pay attention to the Helix case?
Oh, yeah, the Helix case. That the Supreme Court of the United States actually issued their opinion yesterday on that.
Now, so this is very interesting to me because I've handled some of these cases. As you know, we're in Southwest Louisiana, so we have a lot of rig workers, or not even just rig workers, but oilfield service company workers. And what the Helix case found was that they simply paying them, I mean, it was a long opinion that covered a lot of areas, but getting a day rate in itself does not prevent you from getting overtime.
No, and the way that particular company, which Helix was the company, 𝐒𝐻IT was the guy that worked for him. Helix looked at it, and there's an exception that gets used mostly in the oil field and some other places. It's one that's separate from those first three that we talked about, and that is that it's called the highly compensated employee. And roughly what it means is if somebody makes over it's about $100,000 a year. It's like $107 and some odd numbers. Then we can actually take that first test I talked about. Remember I said it had to be a primary job duty? Now it just has to be one of their job duties if I'm paying them a whole lot of money to do it. And in the oil field, the reason I say it happens there a lot is you tend to have a lot of people in the oil field who make a lot of money without any kind of professional training. They did not go to school for what they do. They've been doing it a long time, and it's a lucrative business.
And they're also not in a managerial position.
Correct. So with Mr. 𝐒𝐻IT, he was making almost $200,000 a year at the time. So he was well over the highly compensated employee salary requirement. The actual salary requirement when we talked about the first test is even lower than that. It comes out to about $685 a week is what you need to be making to get over that hump. Mr. 𝐒𝐻IT was making almost $1,000 a day. That was his day rate. So that's what we're talking about. The way the company paid him is every day you work, we're going to give you that much money. And every day you don't work, you don't get paid. In the oil field, because we can't expect somebody to go live on a rig 365 days a year, work 12 hours a day, and spend your other 12 hours a day sleeping on the rig, they tend to work in what we call hitches, right? They'll go out there for 14 days, and then they're home for 14 or 28. So typically your oil field worker will work about half the year. The problem Mr. 𝐒𝐻IT had, or Helix had, was they tried to say, hey, we were paying him a salary. And the way the Supreme Court looked at it said is that salary has to be consistent. It has to be weekly. It cannot be a day rate. It has to be a weekly salary. And what happened with Mr. 𝐒𝐻IT is, yes, he got paid when he was at work, but he wasn't paid weekly because when he was back home, he did not receive a salary. So when they look at salary, they really want to look at basically this person knows they're going to make money every week of the year. They're going to work roughly 40 hours. They may work a little less. They may work a little more. And that's where the law wanted to give companies a flexibility with certain high-level employees of, I don't want to have to manage every minute of your day.
But that also comes down to overtime too, right? The way they calculate the hours when they were on their on shift, they should have been paid 24 hours a day, essentially? Or
well, in Mr. 𝐒𝐻IT's case, he was working, and with those 12-hour shifts, usually those guys, when they work offshore, they're working 7 days a week, 12 hours a day. It comes out to 84 hours a week. So you'll typically see that in oil and gas industry is that people's paychecks will reflect they worked an 84-hour work week usually.
Okay, so he should have received 44 hours of overtime per week.
Correct.
But they didn't pay him the 44 hours.
They were paying him roughly $1,000 a day.
Now, from my experience, what they do is they take the salary and the day rate, divide it to figure out the hourly.
Yeah. I mean, look, I've worked plenty of places that we've talked about. I worked in some big companies before, and the way these payroll programs work is they got to figure out what your hourly rate is. Even if you are on salary, they will deduce it to an hourly rate. So that's where the lawyer that maybe was representing Mr. 𝐒𝐻IT can come in and say, well, now we know his hourly rate. We know he worked 84 hours a week. This obviously was not enough money to cover all those time and a half. So, right, when we get over 40 hours, you got to pay me not only what I'm owed that hour, but also an additional 50%. Some people get real in trouble with this because not only are they not paying the 50%, they're not paying the whole hour after 40. So if Chaz works 44 hours, but you're on salary, I'm only paying you for 40 hours.
So all these all these day rate cases, I mean, they're going to start dropping like flies, right? I mean, the Supreme Court just ruled on it that day rates are illegal. So if you're getting a day rate now, you need to contact a lawyer.
Probably so. I mean, they've been dropping for a while now. It's been bubbling up as it does in the law world. We're slow. Right. Things happen slowly, and the Supreme Court sure is slow because what the Supreme Court likes to do is figure out that there's some miscommunication or there's people that don't exactly agree. When we talk about people, the courts don't agree with what we're going to do. So they're only going to address it when it's become a real big issue nationwide.
Let's talk about the interview process. Okay, so job posting is legal. You get to the interview. What are some of the missteps a small business can make in an interview?
So there are certain things in interview you absolutely cannot ask about. You cannot ask somebody about their medical information because that gets you into whether or not they have disabilities. And you cannot ask them about genetic information, their family's medical history either. That is off limits completely. Even if you notice they have a disability while you're interviewing them, right? The guy may have a disformed hand or some other thing that's going on. You can't specifically ask, hey, what happened to your hand? But I could say, hey, this job requires you to do a lot of typing. How do you think you're going to be able to do that? That's actually asking questions about the job and not about your disability. So those are things you cannot ask. What are some things you should avoid? You should avoid things that'll get you in trouble with those protected classes we talked about. So one of the protected classes is pregnancy. So I've seen people straight up tell their employer that they're going to be pregnant in an interview. That can be real troublesome because now you have the information and you don't want to discriminate against it. But there are cases where, hey, where'd you go to high school? Oh, great. They say it, whatever. And it's just trying to be conversational. And then you're like, what year did you graduate? But now I've asked a question that establishes how old you are. And now that person who maybe didn't get the job says, oh, well, you didn't hire me because you knew how old I was because you asked what year I graduated, even though you didn't say how old are you. So there's little questions like that. I've seen where they ask about, hey, are you married or not? Because they're trying to figure out whether or not you're going to get pregnant soon.
Besides listening to this podcast, how could a small business protect themselves? And where can we find a script or questions to avoid? What's the best way?
I mean, one of the best ways I've found is that the federal government and our state governments do a pretty good job of giving you fact sheets and tips and guides of how to not go afoul of the law that they are the ones in charge of enforcing. So go to the EEOC.gov. That is the Equal Employment Opportunity Commission. That is basically there to make sure that all the things we're talking about today are done in a fair way.
If you innocently ask the question, you find out that the female applicant volunteers that she's pregnant or whatever. How do you document that you're not hiring her for a different reason?
You need to make sure that you have those bona fide job qualifications, right? It comes back to your job posting. Here's the things I said need to be successful to do this job. Here's why applicant A was better than the one that told me she was pregnant. It's not because she's pregnant. It's because they were better at all these qualifications that I said were important to the job.
I thought that interviewing and hiring people was a lot more, I'm not going to say roll the dice, but was not this intense.
I mean, another part of it, too, is probably you think I get in this interview and I just kind of want to have a conversation. I'm not going to have a list of questions.
What's wrong with that?
The problem with that is now I could have somebody that says, well, you asked that question of me because I am African American or I am female and you were trying to get more information to disqualify me from getting the job. And you didn't ask that person before me. You didn't ask that white guy those same questions. So I would tell somebody, if you're going to have a list of questions, you have to ask every one of your applicants every one of those questions.
Can I assume that the bigger the company, the more the target for that type of situation?
Really, where you get in trouble, especially with the bigger companies, is because they're doing so much hiring, especially when they start getting that big, you end up with retention and turnover that it becomes the fodder for the class action attorney. Because if you do that in one case, a lot of times companies do have consistent hiring practices. I can tell if you broke the law or you did it incorrectly in this one case, you're probably doing it the whole time. And now I can go and bring a class action suit, which can cost millions of dollars. I've seen that happen.
Since this is so intense, should each company have a designated hiring person that has special training in this type of thing?
I would tell you, if you can afford to, you should have somebody who has HR experience, a human resources person, if you have that in your company, in every interview.
Yeah. And going back to our first podcast, just because it doesn't happen or just because you haven't seen it happen doesn't mean that you shouldn't put this in place for if it happens to you.
Yeah, because hopefully your business is going to get more successful, and as you get more successful, the target gets bigger.
Right. So someone right now, probably hundreds of people right at this second are being discriminated against by interview questions, and nothing will ever happen come up.
And part of it might be, I mean, if it's not McDonald's, but the other little bitty hamburger shack on the side of the road, there's probably not enough money to go after. Right. And like we said before, lawyers need to make money, and so do all other people. So that's where the issues come in. But thankfully, our laws actually have places and things in place that will protect you. Like you can go make a complaint claim to the EEOC, the Equal Employment Opportunity Commission, and they will actually investigate it free of charge and see if there was anything done wrong. And then if they do find wrongdoing, they will actually give you the green light to sue the person. But now you have this piece of paper with a finding from the federal government saying that you did do something that was against their regulation.
Is that required to file a suit?
It is not.
Okay. What's the point of that? Just
it's a free resource, really, right, to get the ball rolling. It's almost like, hey, this gets me to the place where we can have some meaningful discussions between me and this potential employer about whether or not they really did discriminate, and they may want to rethink how they did that hiring process.
Does the EEOC, does it have any teeth? Can they fine or penalize the company at all, or is it just a service that they do some of the investigation legwork for the employee?
They have some teeth, but I think most of the time they choose not to use them to their fullest extent. Like I said, by them giving that finding, that's usually enough for somebody to go get a lawyer and then go farther with their claim.
How does someone start a claim with EEOC?
You can go straight to their website and find their local office, and I think there's even ways to make some electronic claims as well.
Talk to me about background checks.
Oh, man, background checks. Here's one where you can get sued in the class action real quick, too. So we all want to figure out, and sometimes we have regulation requirements, to look into somebody's criminal history. In certain industries, you can't have certain felonies or certain crimes on your record and still be eligible to work in that particular position. One of the things you have to do, though, is we actually have another law that comes into place here, and that's fair credit reporting. Because we're looking at, just like you look at somebody when they go get a loan, we do a credit check. A background check's kind of the same thing. So that law came into place, and it said, first I have to have my consent to do my background check. So I fill out a job application. Usually on that job application, you have enough information to go give to a background company and say, go find out about Chaz's history. I want to know if he's been arrested. I actually have to ask you, is it okay if I go do a background investigation? The way that happens usually is through a form, right? But the thing that's very particular about this is that form has to be very simple. Some people want to put all this stuff in there to cover themselves, put all the big lawyer words, make it long, make it part of some bigger thing, and maybe hide it in the fine print. That is not allowed.
It has to be open and unambiguous.
Yeah, usually I tell people that thing needs to be 1 page or less. And it needs to be its own document, and it can't be part of everything else. So you'll see a lot of times people get aggravated too when they're going through the onboarding process and they're signing 16 things. Why do I have to sign so many different forms? But it's so to make sure you read this form and you understand that I am giving this company and their investigating agency permission to look into my past. So that's the very first thing you got to do. And I have actually seen that turn into multi-million-dollar class action suits because that form was not correct. The next thing you got to do is, now I sent it off. I got this information back, and there is something on Chaz's record that looks like it could be a problem. You have one of these felonies that I can't have in my industry. So what do I do about that?
Or bad credit.
Or bad credit.
Or theft.
Theft. There's a lot of times where some of those fraud type of crimes are usually would disqualify people too. But I see that on there. So, okay, I know I can't hire you, right? Do I just stop there, tell you, hey, sorry, you're not making it past the next round? No, I can't. I actually have an obligation under the federal law to let you know that something came back on your background report that could disqualify you from being employed by me. So I need to tell you that. And the way I do that is I send you two things. I send you a copy of the report I got and a page that has your summary of the rights that you are afforded. So I have to give you an opportunity to know why I might not hire you. This is before you make that decision, because I have to give you the ability to go contest that. You may say, hey, that charge got dropped. It shouldn't be showing up as an arrest or a conviction. Maybe I got it expunged. Why is it still showing up? You can go over to that background check company, show them the proof that their report is incorrect, and then they could correct it. And now you actually have an opportunity to get that job because that restriction is no longer on you.
And again, I'm going to ask you this. Is this for small companies as well as big companies?
For all of them. Really?
Mm-hmm. And so this is a lot.
Oh, and if you actually do get that person, right? Chaz goes and does all of these things and he can't clear it all up. I still have to send you a letter if I make that decision to not hire you based on that information in your background check. So I have to get your consent. I have to let you know if something popped up and give you a chance to fix it. And then even after that, if I decide not to hire you based on your background check, I have to tell you that that's why I didn't do it.
And that's, would the same thing apply to credit checks? Is it just the criminal side, or is that?
It's anything in that background check investigative role. There's even some companies that do investigative checks where they'll actually interview and talk to people. And it's not necessarily just the paperwork, right? What's in the criminal record system or what's on your credit report. And that stuff's covered under that too.
Wow.
You were talking about discrimination-based hirings and whatnot. Is there a federal law that does what the NFL does when it comes to the Rooney Rule? Which the Rooney Rule for like hiring head coaches, you have to interview at least two. It says clubs must interview at least two diverse candidates from the career development advisory panel list, or a diverse candidate not currently employed by the club. Is there a federal law that does that, or is it private businesses like the NFL that implements practices like that?
Well, the way you know there's not a federal law around is the fact that the Rooney Rule exists, right?
Right.
So if there was a federal law, then the NFL wouldn't be coming up with their own rule because they would have to do it.
But is that commonplace among other large corporations, businesses like the NFL?
I mean, there are companies that are going to do it, especially when you get larger. You actually have some other areas of the law that require you to have some affirmative action programs and some other things in place. So, I mean, there are places where, yeah, having diversity and inclusion, not just because it's good for your business, we talked about that before, but it is, in some instances, required that you show that you are being diverse and inclusive.
But you don't know. I mean, so affirmative action, is that still the law of the land where there's actually a federal mandate to hire certain minorities?
Well, there's not a quota for it, but there is. You need to have a showing that you are at least taking it seriously. And so usually they do that through some sort of demographics. You show some percentages of these are the amount of people I have in these positions, or these are my applicant pool and here's how I hire, right? There's a thing about that is I could have a population that is 20% African-American, and then when you go look at who I hire, I'm only hiring 5% African-Americans, right? There's a disparity there that could be an issue. So most of the affirmative action things go around reporting back to the government, but that reporting could show that there's some problems.
If I wanted to hire a paralegal or a lawyer, and I realize this is probably not a good example, but how can I make a determination if I want to hire them as a contract employee where they get a 1099 where I cut one check, or if I have to pay them as a W-2 employee?
So there are some tests. There used to be, the IRS had like a 20-factor test, and it covered a lot of things that the two tests I'm going to tell you cover. They just kind of boiled it down to its essence. Right now, we have a common law test that determines whether or not you're a contractor or an employee, and the assumption is you're a contractor. We have to prove that you're an employee. How do I do that? It comes down to behavior, right? Do I make you, or do you act as my employee? Are you wearing my logo when you go to work? Are you going by all my rules? Are you telling people I'm an employee of Chazrobertslaw? Then we go to financial. Is our entire relationship based around you working for me at a certain rate, right? Is it I'm paying you hourly? Are you working 40 hours a week? Because there's a part about that relationship too. Is it indefinite? And is it so pervasive that there's no way you're going to go work somewhere else? Right?
Can I control the way you work is another one, right? Control. I said I was a bad example because I'm hiring professionals, right? So the lawyer, if I hire another lawyer on, that's not the same. What would be an example of a contract employee that's being treated as a contract employee but should probably really be a W-2 employee?
You could for certain do that with a lawyer, right? Any lawyer could, and we know that with our profession, have the ability to be our own boss and be our own business. I can go do that right now. But you could have somebody working for you that you said, hey, you're a contract employee, but you have them work to an extent and in a way that they come off as your employee. You have them working 80 hours a week. Everywhere they go, or every time they come to work, they got to put on the CR logo, right? And there's all those things that get into those factors that even though they have the ability to start their own business tomorrow, that doesn't mean that they are necessarily an independent contractor just because they have that ability.
Because of the way we are treating each other in the relationship.
It is the amount of control you have over the person is essentially what they're looking at.
Can you think of another example of someone out there who is probably being treated as a 1099 but should really be a W-2 employee?
You get right back to our oil field people out there. Right? A lot of them work as independent contractors in some instances. In some parts of those fields, everybody that works out there, maybe they went around for a long time with pipeline inspectors. There was a lot of lawsuits that went around from there of people that were working as independent contractors and being paid a day rate. So not only were they coming back and saying, hey, you owe me overtime, but you also misclassified me that whole time.
Yeah. So if you don't show up at 8 o'clock, you're gone. If you don't have my logo on your shirt, you're gone. That looks a lot more like an employee instead of a contract employee, right? Yeah. How does Uber get around it?
So Uber gets around it in some of those ways is that person isn't so contracted, right? When you get on Uber and you get the app and you're a driver, you get to choose when you're going on the clock and when you're not. The lawyer that comes work for Chazrobertslaw can't say, hey, man, I'm just going to work from 12 to 3 in the morning, right? You're like, hey, I need you here from 8 to 5. That's when the phone calls come in. That's when our clients are here. You put some control over their time. Uber kind of doesn't give them, that gives them a lot of leeway. Plus, you can go do other things. That's a big part of those tests is this person truly an independent contractor? In other words, is this their business? Are they out there doing other things to make money? So I could go work for Lyft and Uber at the same time. A lot of times you see people with 2 phones in their car and they're running both apps at the same time.
I understand. Yeah. How about like, I guess a doctor working for a hospital?
He can have his own practice too.
He can have his own practice. And he can choose what days he doesn't want to work.
Right. So you have to worry about how pervasive that relationship is with that person. I have you crossed over into that area where they are now an employee versus an independent contractor.
Someone that's treated as an independent contractor but should really be a W-2, what recourse do they have? How would they go about?
Well, the first thing I would say is go talk to your company and your HR department. But now if they are adamant that they have classified you correctly, there are some different ways. You can go to your state authorities or the EEOC. I mean, that, once again, you always have your federal and state agencies that'll help you out. A lot of times people don't want to go bring that issue if they're classified as an independent contractor because most of the time you find out that not only the employee but the company both want that status because when you're an independent contractor, all that money I pay you, you can now treat it as a business and write off all kind of expenses that an employee isn't allowed to do. So a lot of the crackdown you've been seeing from this part of the law is not coming from your own person suing you if you're the business owner. It's actually from your state authorities who are coming in because they're missing out on a lot of taxes. So you're going to get crackdowns on this particular subject regardless of you treat everybody in your staff really well because it's not so much the employees that always bring up the issue, but it's the state authorities.
Unless an employee doesn't save enough money to pay their taxes at the end of the year, and then they'll play ignorant to that fact and say, "Oh, I didn't know you weren't taking the taxes out of my check."
They can try that, but that ignorance of the law is not a defense, right?
Right. Well, good, man. Scott, thank you for coming on. You answered a lot of our questions on hiring. Fire as always, buddy. Thank you.
Thank you.
Hey, it would mean the world to me if you subscribe to the podcast and leave us a 5-star review. It helps keep the show free, and it helps us book better guests to provide more valuable content to you. None of the opinions expressed by my guests are that of my own, and nothing we talked about creates an attorney-client relationship or could be construed as legal advice. Hope you enjoy the show.